Good evening and welcome to Slam the Gavel, the show that tells it all regarding family court, other court issues, as well as CPS. I am your host, Marianne Petrie. This episode of Slam the Gavel is sponsored by CPS Protect Consulting Services. A child protective services case is one of the most frightening experiences for any parent. Don't face it alone. Face it with confidence with Urgent Assist. By CPS Protect, you can have access to former CPS investigators to make sure you preserve your rights and protect your family. If you're facing CPS involvement and aren't sure where to turn, their child welfare consultants can help you. Visit cpsprotect.com/subscribe and enter the coupon code Slam the Gavel for 60% off your first year of Urgent Assist. And this is available in all 50 states. I have another announcement. Bradley's mother, Narcus Golan, passed away in the fall of 2022. Bradley is autistic and needs structured and routine therapies he receives for his autism 6 days a week. However, Italy just entrusted Bradley to the Italian Social Services. If he's ruled to go back, he will face the next 3 to 4 years in the Italian foster care system where he can't speak or understand the language. He will then be taken away from the only family he has ever known. Please call Governor Hochul, New York State, 518-474-8390. That's Governor Hochul, 518-474-8390 to please keep Bradley here safe in these United States. Hashtag keep Bradley safe. Another announcement, go to the site pleasedoyourjob.com. We need 2,700 more signatures to get a case reopened. This is very, very important. That's pleasedoyourjob.com. One last announcement. You're invited to the Interference with Child Custody Coalition Custodial Interference Press Conference on October 31st, 2023 at 10:30 at the PA State Capitol, Harrisburg, PA, in the main rotunda stairs. So hope everyone can join. I have a return guest. I have Predrag Tosic back on. He was last on season 3, episode 161, where he spoke out about his case, bias, domestic violence, and the abuse of Title 4D. And we're going to talk about ADA rights and how he's been unemployed for 2 years, and yet they're expecting an exorbitant amount of child support from him. So I welcome you, Predrag. How are you?
Thank you very much for having me again. Well, as I shared earlier, I have either hearings or court deadlines every week for the past roughly since December of last year. The state is going after me, and of course, until the matter is moved to federal court, I don't expect any justice or even being meaningfully heard. The state is pursuing manifestly fraudulent orders, orders that are null and void because they're based on documented proven fraud. And when I raised that in the court, first I challenged the court's jurisdiction. They said, well, we have the jurisdiction. Then I raised these fraud matters and I said, look, with or without jurisdiction, I can do a collateral attack. There is plenty of US Supreme Court and other higher courts case law about collaterally attacking orders that are null and void for any number of grounds. The court that made the orders didn't have the jurisdiction. There is proven fraud and so forth. And they say, well, no, we don't want to look into this because it's another court and, we don't want to deal with it. So I'm like, you're stating that you have jurisdiction over me and over the case where you actually don't have a jurisdiction. You certainly haven't proven it, and I keep challenging it. It's currently at the motion for revision or reconsideration stage, one or the other. I always mix up the terminology. But then something that is a collateral attack that I'm perfectly, this was from the administrative court in Washington State. It's called Office of Administrative Hearings. And then I'm before the Superior Court in the county where I reside, Spokane County. And so it's a court of higher jurisdiction. It's a court of general jurisdiction. It's perfectly legitimate and lawful and procedurally appropriate to make a collateral attack. And by the way, when there is fraud involved and when orders are null and void, there is no statute of limitations. No, they haven't brought up state because some of this fraud dates 5 years back or close to 5 years back. There's prima facie evidence of fraud coming from state-owned sources, by the way, such as the Division of Children, Youth, and Families. And I put all that together. The state, the county deputy prosecutor, hasn't challenged this. The court so far has been refusing to review it. So they're going after me for bogus child support, even though the state itself found me indigent a year and a half ago. They were extorting so-called child support throughout. Excuse me. Throughout not only my employment period, but also during my period of unemployment while I had, at least in Washington, it's up to 26 weeks, the so-called unemployment insurance. So I did have income, even though I didn't have salaries and wages. They didn't adjust the amount or anything. They just kept taking the same amount. Then when that expired, and this is roughly the time where I realized that I need to look for disability benefits, because multiple of my counselors said that I've been immensely traumatized. There is one counselor statement at the trial in 2021 to this effect, sworn statement that wasn't challenged by the opposing counsel. Of course, it was ignored by the judge because it's a kangaroo court. But at least I have track record of it. I'm submitting that to the Division of Child Support. I have submitted that to the federal authorities, the Social Security Administration, and I'm certainly going to submit it once I finally manage to file a federal lawsuit against this corrupt state and its actors and its so-called family court, as well as its appellate courts. And so with regards to what I spoke about last time, I'll maybe briefly summarize how this Title 4D abuse takes place, but then I'll focus on lawlessness and abuse and systemic violations of the Constitution and constitutionally protected rights in the state of Washington appellate courts. So a year ago, I talked about family courts in the state being kangaroo courts, and it's an understatement. They're worse than kangaroo courts. They're joint criminal enterprise, literally. The outcomes are predetermined. It's all for the show. Rules of evidence are ignored. I have undisputed sworn statements by the police officers, for example, with regards to the domestic violence incident that reinitiated the custody battle. It was completely ignored. The opposing counsel did not say the police got it wrong. The police got it right. It's a video recording, not my video, security camera video. The so-called family court judge ignored it. So the moment it goes from the criminal court to the so-called family court, literally black becomes white. Undisputed evidence is ignored. Undisputed sworn testimonies and affidavits are ignored. This is all against the law. It's against the massive case law with regards to undisputed evidence and undisputed testimonies from the U.S. Supreme Court and other higher courts. It doesn't matter. It's a family court. Rules of evidence don't apply. Perjury doesn't apply. Ex-wife and her attorneys have blatantly lied under oath. This is not my opinion. Whenever I bring that up, they tell me it's your opinion. Here's the record of what she said under oath. Here's the record of what she and her crooked lawyers, and she has had some of the worst scumbags with law degrees that are in the state of Washington. One of those scumbags, who is also going to be named in my upcoming federal lawsuit, is now a commissioner, full-time commissioner on the same bench as the tyrannical, abusive judge, this Honorable Sean O'Donnell, who has, taken my rights as a parent, said that I can psychologically negatively affect the child, and that's why they slammed me with what in Washington is called 191 restrictions for the abusive use of conflict. And let me just, before you move to the next question, maybe just give you an illustration how these kangaroo courts operate. My so-called abusive use of conflict in judges' ruling from 2021 are based on me calling the guardian ad litem a lying crook, which I did do. The guy is a lying crook. He should be in jail, but corrupt judges are protecting him. His friend and neighbor in Bellevue, Washington, they were literally neighbors down the street from each other in the same niche industry, which is the domestic violence assessment and treatment, which of course in the state of Washington is a complete joke. Certainly in King County, it is a complete joke. The guardian ad litem never acknowledged conflict of interest. They pretend not to know each other. They're 2 out of 5 total licensed domestic violence evaluators, and their offices were down the street. Now, Bellevue isn't New York City, but it isn't that small. It's like the 3rd or 4th largest city in Washington State. And so there's about 55 to 60 licensed DV evaluators across the state, 5 in Bellevue. These 2 were down the street from each other. They appear in the same court as expert witnesses, but they've never heard of each other. And then Mr. Paul Eagle, attorney Eagle, who was representing ex-wife, Heather Blakemore Thomason, formerly Heather Tosic. It was known at the time of the trial in 2021, that he'd be joining the family law bench of the same King County Superior Court. At the time of the trial was September 2021. At the time of the and I raised that and it was ignored. Judge O'Donnell said, "Well, I wasn't involved in hiring or interviewing Mr. Eagle." That's irrelevant. By the time of the ruling in November 2021, Mr. Eagle had Sean O'Donnell as his boss. He was on the same bench of the family court. I checked with I forget now whether it's the clerk's office or the court administration. Sean O'Donnell has been the supervisor because he's not the presiding judge of the entire court, but he's like the chief what's in Washington called Unified Family Court judge.
Mhm.
And all these commissioners, he's their immediate supervisor. I raised that conflict of interest together with the
Mhm.
guardian ad litem and the DV evaluator conflict of interest. It was all ignored. I raised it then with the Court of Appeals, Division 1 of the state of Washington, completely ignored. When I filed certain documents and made allegations about this conspiracy against protected rights and violation of protected rights per 42 U.S. Code 1983 and 1985, respectively. 1985 is conspiracy, 1983 is violation of protected rights under the color of state law. It was denied by the Court of Appeals Division 1, and only commissioners justify their rulings. Usually it's complete nonsense from my experience. And then in their infinite wisdom and arrogance, the panels of judges, they just deny without even justifying. So the only justification that I have from Commissioner Kanazawa is her name, was basically that it was my opinions and it was conclusory. So I subsequently motioned to modify, and then when I elevated to the state Supreme Court, included pieces of transcripts, prior sworn affidavits, that I raised issues of corruption of the guardian ad litem, the DV evaluator, the conflict of interest between the two, the conflict of interest between ex-wife's attorney and the so-called family court, so-called judge.
Mhm.
Then it was denied without any justification. Then I elevated it to the state Supreme Court. It was denied there as well. And then the state Supreme Court imposed restrictions on how much I file. Well, you said it was conclusory. It was my opinions. I struck through the word limit, word count limit, and so forth. I included some limited exhibits.
Mhm.
And they came up with this, conclusory BS. It wasn't conclusory at all. There is ample record to support what I was alleging. And then when I included documents, including pieces of transcript, and then I did submit as exhibits and attachments, hundreds of pages, I will say that. Because don't tell me it's conclusory. Here's the evidence. You're just ignoring it. And then the Supreme Court, in their infinite wisdom, the Supreme Court of the sorry excuse of a state, that is today's woke Marxist Republic of Washington State, basically imposed it, first of denied without justifying why my multiple motions were denied, motion for stay, motion to remove the commissioner for bias and prejudice and First Amendment retaliation against me and so forth. They denied everything by a fiat. And then they basically imposed restrictions on how much I can file because I filed too much. Now, it is true that I filed more than it's customary. However, my intelligence kept being insulted at the Court of Appeals Division 1, how well documented. It's all a part of the record, and I'm providing either reference to the record or even direct records. How it's conclusory. And so when you go possibly a little overboard saying, here's the record, here's why it's not conclusory, I'm literally referring to what's on the record at the trial court and the appellate court, then they say, well, you filed too much. What's also clear from both Division 1 and the state Supreme Court is that they don't treat pleadings. They treat proper or pro se parties with utter disdain. They're endlessly arrogant. They know that they're not accountable to anybody. I've never seen, they blatantly violate your rights. And when you point it out to them, they just ignore you. And this applies to the due process and equality before the law rights that have been violated at the Court of Appeals Division 1 throughout since the spring or summer of 2022. That also applies as of more recently to the ADA, Americans with Disabilities Act rights. And I say most recently because with my ADA advocate's help, Joan Kloth-Zanard, to whom I'm very grateful, I've only filed for those protections relatively recently in the spring of 2023, protections at the Court of Appeals Division 1 and the Spokane County Superior Court. Now, at least Spokane County Superior Court is paying some amount of attention to it. I filed with it's either called presiding or chief judge of that court. I haven't gotten any written rulings, but it does appear that they're paying some minimal amount of attention. The worst denial of due process that I have experienced, and whoever is watching your show, if there is anybody who does the civil rights and tort, especially in the federal courts in the state of Washington, I would appreciate if they contact me or if they contact you, and so you can connect them with me. But the worst, the blatant denial of due process, beside the kangaroo so-called family court where due process doesn't exist, it's a joke, it's a farce, was by the sorry excuse of appellate court, that is the Court of Appeals Division 1 in the state of Washington, where there were some deadlines for the main appellate brief. earlier this spring, I reported being ill and I documented it, including submitting confidential. And then once I met through common friend Luigi Di Ruba, once I met Joanne, virtually met, we were on the opposite coast, Joan Kloth-Zanard, she helped me out insofar as putting together ADA requests just procedurally, whether it's oral hearings, whether it's, being allowed to have transcripts, whether it's, breaks during the oral hearings, whether it's a little additional time to draft my own motion since I've been pro se / proper all along. So I filed for ADA accommodations timely with Court of Appeals Division 1. 4 days later, they dismissed my main appellate brief because it's late, in spite of prior evidence of my sickness, even prior to having met Joanne and with her guidance submitting the ADA. I'm just reporting being repeatedly ill, which is documented, which is not, again, my health has been destroyed from years of abuse by these sociopaths.
From the stress.
Including the ones in black robes, especially the ones wearing black robes. And they are narcissistic, egomaniac sociopaths. How did these people get to decide about other people's lives is mind-boggling and should be deeply concerning to anyone who cares about well-being of the society and the men and women in the society, and especially of children, given that obviously in my case, everything stems from the original child custody case. So anyways, I have filed for these ADA accommodations with Joanne's guidance, let's say June 12th or so. Then I amended what I filed around June 14th or 15th, and then June 16th or 17th. They ignore it. So it's a pending motion. Mind you, it's a pending motion because it's a request for ADA accommodations filed as a motion. They dismiss my appeal on the grounds of lateness. I remind them, and there were actually other pending motions too, but in particular, there was pending motions related to disability and ADA accommodations. They say, well, the next step for you is to file motion for revision or motion to modify, whichever it's called, at the appellate court. And, you have something like 20 days. So within those 20 days, I file the said motion. I document further my ADA request, including its timeliness. And I complete actually the appellate brief. So I submit all of that early July. And a couple of weeks later, the same judge who ignored the ADA, there were 3 judges because it's a panel of judges, denies my motion for reconsideration, ignores the brief, and I'm like, this is ridiculous. They say, well, you can go to the state Supreme Court. I have filed with the state Supreme Court, the same Supreme Court that spent little to no time reading my pleadings, plenty of time coming up with how to restrict what I may or may not file. If they spent a comparable amount of time on actually looking into the matter and the violations of the trial court, but they didn't, because again, they too are protecting criminals in black robes at the lower courts. It's corrupt all the way to the top. And so now it's pending at the state Supreme Court. They acknowledge, their clerk acknowledged it's going to take months. And then we're going to debate whether I was denied due process or not. It doesn't take law degree to realize this is a blatant denial of due process. And then it may or may not go back. Of course, if it goes back to the corrupt as hell Court of Appeals Division 1, I'm going to seek that it be moved to Court of Appeals Division 3, where I reside. Court of Appeals Division 1 and King County were never a proper venue. My daughter was born in Pullman, Washington, which is 75 miles south from where I am. So that would belong to Whitman County. I live in Spokane County now, and both Whitman and Spokane counties belong to Division 3. But more important than basically legitimizing parental abduction by the mother is that Court of Appeals, which is what state courts, including Court of Appeals Division 1, have done to date, is Court of Appeals Division 1 is corrupt as hell. They're no better than the Kangaroo Family Court. They blatantly violate rights to the due process and the proper appellate process. They blatantly deny the right to be meaningfully heard. And last but not least, in this staircase of depravity and of violations of my rights, they violate ADA and disability-related rights. Now, sometimes courts review and deny someone's request for ADA accommodations. Please keep in mind, they simply ignored it. They ignored other motions too, but they ignored a motion for ADA recommendation citing why I claim a disability. It was filed timely. And then when I remind them, then they say they just denied without justification. On around June 20th, when this, hey, didn't you see I filed for ADA accommodations and you've ignored it?
Mhm.
A commissioner, the same commissioner Kanazawa, coincidentally, there are two commissioners, they're both awful, but one is worse than the other, literally said, well, the court has already dismissed this appeal on, let's say, June 15th. Mr. Tosic has filed so-and-so on June 12th, so certainly multiple days before. And so his request for ADA is now moot.
Mhm.
So they know that my filing was several court days prior. There were no holidays during several court days prior to the case being dismissed on the grounds of lack of timeliness on my part. And then when I filed for reconsideration, the brief for which I did need additional time was done. They ignored it. They
Mhm.
still denied reconsideration. Said, well, if you don't like it, you can go to the Supreme Court. So this is what these tyrants in black robes do. They literally want to either cause you a heart attack, or
Mhm.
that you go broke and homeless, or that you just give up because there is no winning. It doesn't matter what evidence and argument you provide. They ignore it. It doesn't matter what federal statutes or constitution or what you cite, whether it's the rights to the due process and to be meaningfully heard, whether it's the rules of evidence, state and federal, or whether it's most recently the ADA and disability related rights per federal statutes, 504 and off the top of my head. Again, all properly cited with Joanne's help in my written pleadings. They simply ignore it. And they say, this is what we rule. If you don't like it, you can file for modification. If you don't like denied modification without any justification, you can go to the state Supreme Court. I mean, nothing is going to improve in my
Mm-mm.
case until I reach federal courts. That was clear a year ago. But these abuses, let's just call it what it is, abuses by the state appellate courts
Mhm.
are further evidence of a massive level of corruption in Washington state and its judiciary. B, that this whole idea, oh, you have to exhaust the state route. So people waste years, tens, hundreds of thousands of dollars, years of their lives, spinning wheels where it's crystal clear
Oh.
that there is no relief at state courts, including its appellate courts. They look the other way and they simply tell you if you don't like it, you appeal to the next level. The system is corrupt as hell. It's destroying lives. It needs to be completely overhauled. Kangaroo family courts need to be abolished altogether. They're
Mhm.
incentivized the wrong way. They're corrupt as hell. But the difference, or not the difference, the upgrade, if you will, in what I'm sharing with you and your audience a year ago, now, as opposed to a year ago, is that at least in Washington state, appellate courts are no better. Appellate courts operate according to different rules, and I get that. It doesn't matter what evidence you present. It doesn't matter
No.
how much of evidence of violations of the due process, because presumably appellate courts do care about legal and procedural things, even if they don't review, say, the factual.
Well, they don't even review evidence because I
They
was in
don't.
appellate
In
courts.
my,
Nothing.
that's right. They keep refusing reviewing evidence. They keep refusing reviewing procedural violations of the rules of evidence, sworn affidavits and testimonies, if undisputed, if unchallenged by the opposing side, need to be considered true. I had police testify because they commonly in cases that involve domestic violence, commonly the opposing counsel says, well, the police report is hearsay.
Mhm.
So I made sure that the police testify under oath. It was completely ignored. I raised it to the Court of Appeals. Well, the judge found, even if there is evidence supporting Mr. Tosic's, allegations, the judge found evidence supporting the other side more compelling. So I'm
Mhm.
like, what evidence? The judge made up bullshit, said
Mhm.
that me calling guardian ad litem a crook, which he is,
Mhm.
somehow can adversely affect emotional and psychological development of my daughter. I don't discuss with my then 4-year-old, now 6-year-old, the guardian ad litem. So it's complete bullshit.
Mhm.
So the mother assaulting me, my daughter's mother assaulting me in front of the common child, that doesn't have a psychological influence on the child, apparently, according to tyrannical, abusive, lawless child abuser named Sean O'Donnell and parent abuser,
Mhm.
this honorable Sean O'Donnell. I had sworn unchallenged, Marianne,
Mhm.
witnesses. Washington, being a communist state that it is a two, you need the other party's consent. You cannot record, but you can have a friend be present when you're doing, for example, a Zoom or a Skype call with, say, your kid. And so I had friends here in Spokane who witnessed my daughter's mother, I'm not going to mention the kid's name, screaming and yelling at me, showing me her boyfriend. I'm like, I don't care about your boyfriend. I want to see my kid and chat with her. These
Mhm.
are classical behaviors of narcissists and abusers. Now, you can say, if I just say that, unless I have a recording and I cannot record without permission, it's a hearsay. It's she said, he said.
Mhm.
I had my friends here in Spokane witness that, report to the Guardian ad litem, who of course distorted and removed those statements and falsified what my friend said. I had 4 testimonies that the Guardian ad litem falsified witness statements in his GAL report. Nobody cares, including the appellate courts. And then at the trial, the same people who submitted sworn affidavits that were undisputed by the opposing counsel testified on their oath. This was not disputed. It was ignored by the Kangaroo Court and Dishonorable Sean O'Donnell. When I raised that to the Court of Appeals ignored it too, because the judge, if there, we need to defer to the trial judge, and he found the other side's evidence more. I'm like, what evidence more persuasive? That I was abusive or neglectful towards my daughter? There is zero evidence. That I was abusive to ex-wife as opposed to her being abusive to me? Zero evidence. If the guardian ad litem is offended as a good Seattleite that I called him a lying crook, which he is, he can take me to the court for, defamation, slander, and such. Of course, he's not doing it because he knows that he should be in jail, that he falsified witness statements and lied through his teeth, which guardian ad litems apparently commonly do,
Oh,
depending on where
yes.
the money and the political interests come from.
Yeah, because they're third-party parasites.
They're third-party parasites. These are the people who don't have legitimate or very little of legitimate practices as either attorneys or, in my case, the guy is a psychologist. So I was originally excited. I didn't want the guardian ad litem. I wanted ex-wife to be evaluated for specifically cluster B disorders. That multiple psychologists told me that that's what she should be evaluated for. Now, of course, they said, we were not her counselors. We know your stories. The way to go is an independent mental health evaluation. That never happened. Instead, a parasite crook was appointed who lied through his teeth throughout his report, who falsified 4 witness statements, not counting making up things that I never said, things that I never did, taking out of context things that I did say, and so forth. That guy's a criminal, and I'll say his name. William Singer is a lying crook. He's a criminal. He should be behind the bars. But because the judges are protecting him because they're all making money by destroying lives and destroying families in collusion with each other. So
And
he's been protected by the judge.
he's the guardian ad litem.
Yes. He's been dismissed after the trial. And of course, after Dishonorable Sean O'Donnell and a couple of other tyrants in black, Mr. Singer is going to be close to the top of the list of those that I'm going to sue in a federal court, because I'm not going to get any justice in state courts.
Are you suing in on a personal level as well?
Well, civil rights violations and tort. There is also, and I can mention the name, a friend of mine, Washington-based Tony Card, has started what he wants against Pierce and King counties, which are the 2 most populous and also most corrupt counties in the overall corrupt state of Washington. And he's naming some of the same judges, including Dishonorable Sean O'Donnell. That's in the Western District of Washington, federal court. And I spoke to Tony, and he wants me and others to join his lawsuit. He's also suing several judges and commissioners in Pierce County, with which I haven't had anything to do, but I do with the King County, and it's some of the same names. These people, aren't only abusing me; they're abusing other parents as well. And we're to figure out the way forward, because again, as you're familiar, Matthew Phillips, who is licensed to practice law in California, is representing our friends Mark Fidelman, Rob Ebert, and others. I haven't found anybody. Matthew couldn't refer me to anybody. He doesn't know lawyers up in Washington State. But Tony and myself and others, we're like, okay, do we do it on our own? Technically, for a class action, you do need an attorney or a law firm. I have contacted some law firms specializing in tort, and again, I'm appealing whoever watches your Slam the Gavel to contact me or to contact you, finding a law firm that's willing to go against the corrupt system and to represent multiple people, not just myself. Because class action in this corrupt as hell state that's been destroying lives for decades, these tyrants are violating the law, violating the Constitution. They just don't care. Our friends down in San Diego feel, and I know that Rob Emmert was kept in jail for no legitimate reason for a couple of months with his heart condition and everything. What is being done in San Diego and Orange County, that I know from Chris Black and Rob and Mark Fidelman and others, similar, if not worse, has been going on in Washington State, especially this worst of the worst, where Seattle is. King County, Pierce counties, and so a class action is long overdue. So I'm
Mhm.
appealing whoever is willing to fight the system. Hopefully, there are people like Matthew Phillips in other states, including Washington, that are going to step on the plate
Mhm.
and help us out. And this should be a
Yeah.
lawsuit for tens of millions of dollars because the harms caused.
Oh.
Another friend of mine, Stephen Hicks, hasn't seen his son in 6 years.
Oh.
Never been abusive or violent or neglectful or anything like that towards his son. Had obviously disputes with his ex-wife. Um, you know, and Hel Corzado started the lawsuit. He unfortunately wasn't willing to expand it. He sued the city of Seattle and the state of Washington in the federal court, and I support Angel all the way.
Mhm.
I was looking to possibly join his lawsuit, but he wanted to keep it limited. That's his call. And he no longer lives in Washington. He's fortunate enough to have gotten out of this hellhole
Yeah.
of equality. But he has pursued a federal lawsuit with regards to specifically bogus restraining orders. And, of course, there's domestic violence of men against women, and it's a problem. But the issue is when restraining orders, including covering children, are issued based on, I'm fearful of him.
Uh-huh.
Zero evidence, no due process, nothing. Now, contrast that with my situation. I'm not a small guy. That being said, my ex-wife is 6'1", 250 pounds. She's actually physically bigger than me. I'm not getting into who is stronger. Now, being a big woman or a big man doesn't make you violent. Don't get me wrong.
Mhm.
Some of the most meek people I know are guys who are way bigger than myself.
Mhm.
But, she got caught on security camera for assaulting me in front of the kid. There were unrelated to that incident sworn witness testimonies, unchallenged, undisputed by my friends here in Spokane, saying she was abusive verbally while I was just trying to see the kid per parenting plan insofar as video calls with the child.
Mhm.
All of that gets ignored. I did get initially a 1-year protection, which never covered the kids so that the state could continue getting the Title 4D money through so-called child
Mhm.
support. Surprise, surprise.
Mhm.
Um, and then when I sought renewal and we said, look, she didn't assault me again, but we live across the state from each other. And the child exchanges were taking place through kid's maternal grandmother, ex-wife's mother. That being said, ex-wife repeatedly lied about that incident, lied about past abuse, tried to portray, in collusion with these criminals, Linda Irish, the DV evaluator, and her friend and neighbor William Singer, the GAL, who is also a DV expert.
Mhm.
They claimed that I was an abusive ex-husband because I was controlling the money. Total lie. Heather was spending most of the discretionary spendings in her household. That I was controlling her free time. What the hell does that nonsense even mean? And then lying crook, William Singer. So yes, I'm calling that lying scumbag a lying crook. Coached Heather Thomason because there were her admissions that separately from the DV incident in 2019 that led to the reopening of the case, the one that got caught on camera. And I'm going to say this. Everything Johnny Depp said about Amber Heard,
Mhm.
I've experienced repeatedly at the hands of my ex-wife. Everything minus, excuse my pooping in bed.
Mhm.
Apparently Amber Heard is good at that. My ex-wife hasn't done that. What something Amber Heard has not done to Johnny Depp, but my ex-wife, the mother of my daughter, has done to me is biting. There
Mhm.
is evidence. There is the one thing I did manage to subpoena given the HIPAA restrictions, which is the Pullman Regional Hospital's report claiming that, stating, and nobody disputed this, that Heather had self-inflicted injuries. Once I escaped from biting, prior to actually me getting her to the emergency room, it was a Sunday evening in a small college town, Pullman, Washington. That's where her daughter was born, Pullman,
Mhm.
Washington, where Washington State University main campus is. Self-inflicted injuries and suicidal ideation, and it's clear that it was self-inflicted injuries. She bit her arms to the point of bleeding. Instead of ordering a mental health evaluation, the court and this lying crook named William Singer coached Heather to basically finding excuses that she was hitting me and biting me and all that, but it was because I basically stressed her out. So excusing behavior that's not normal, and then basically coaching her to say how she was biting me, hitting me, throwing objects at me, and so forth out of fear. So he was, and I have the Guardian ad litem report where he's literally, and look, it doesn't take PhD in psychology. If you're fearful of someone, you're going to stay away from him.
Mhm.
You're not going to. Heather threatened to come to my workplace back when I was a non-tenure track faculty at Washington State University, again in the town our daughter was born, and come to my office and scream. I have those emails submitted to the court, ignored. Is that the behavior? Let's leave aside what caused it. Is that the behavior if she was fearful of me? And
Right.
again, at the child exchange in 2019, she assaults me because she's fearful. So this lying scumbag coaches her and then colludes with his friend and neighbor in her DV report to basically say, well, okay, even if she was, and by the way, I'm not a perfect person and I'm not a perfect man. I was hit repeatedly. I never responded in kind. I was bitten. I would just escape get out, and then she would start, in some situations, including the one I just summarized, she would start biting herself to the point of her arms bleeding. This is not, and this is the person who has primary custody in this Marxist feminist Soviet Republic of Washington, this hellhole of a polity, beautiful nature notwithstanding. It's corrupt as hell. They don't give a damn about children. All they care is about a Title 40 or 40, depending on the situation. In my case, Title 40 money. It's I grew up in a communist society, and Washington State is just as bad, if not worse, in some aspects. Literally, this is not a metaphor. This is not figurative speech.
Mhm.
Needless to say, I regret the date I set my foot into this state. But back to this guardian ad litem and his role, he coached her, and so did the DV evaluator and his friend and neighbor, to say how he controlled her free time. Yeah, I may have hit him, but that was definitely during arguments. So hitting me and biting me because we had arguments, that's an excuse in Washington State for female abusers and perpetrators of domestic violence, as coached by people who are supposed to be objective, impartial, and to act in child's best interest, not mine, not ex-wife's. The whole thing is a joke. The whole thing is a complete travesty. So she was doing that out of fear. It was during arguments that was okay. When the so-called adequate cause was opened and subsequently granted, only in order for me to get railroaded at this delayed trial was delayed because of COVID. So the period 2019 through 2021, the excuse Heather used for hitting me repeatedly with a car door, and I believe I shared that video with you last year. If I haven't, I can do that now, was because I was running late to an exchange. I was minimally late with a kid who had a poopy diaper. The child was 2.5 at the time, 2.5 at the time, so she wasn't potty trained yet. I communicated, and this is across the state of Washington, 280 miles, 170 of which I drive, 110 the other sides drive. I always drive the longer distance. But even leaving all of that aside, running late because I need to change the kid's diaper in a
Mhm.
rest area is an excuse for physical assault. Welcome to the woke Soviet Republic of Washington and its corrupt as hell judiciary. And this corruption, yes, goes all the way up to the state, to this politically, ideologically motivated, and of course protecting their bodies in black, corrupt state Supreme Court.
Mhm.
So I'm an intelligent man. Of course, I'm traumatized and stressed out. It's crystal clear. In state courts, I'll never see any justice. They're protecting for each other. They're not accountable to anybody. The Washington Commission on Judicial Conduct is a complete joke. I have filed complaints with them. They're a joke. They're literally a joke. I filed complaints about the guardian ad litem and the DV evaluator with other state agencies, those that are issuing licenses for these so-called DV experts. One agency, the DSHS Domestic Violence Unit, refused to investigate, and the other, the Washington State Department of Health, ran an investigation, which was a complete joke, and which again I was portrayed as being a dangerous man. And the guardian ad litem, for example, stated, "Hey, why is Mr. Tosic so much against me? I recommended shared parenting, equal parenting." You look at the guardian ad litem report; he recommended the opposite of that. Do you think that
Mhm.
this investigator bothered, this so-called investigator? She's getting sued with her management chain too.
Mhm.
I'm going to mention her name too. The fake investigator, her name is Lisa Noonan. Um, I filed for reconsideration. They sat on it for a few weeks and they said nothing to find here. So what Ms. Noonan did in her fraudulent fake investigation and fraudulent report, she cited William Singer's lies. I said, look, 4 people submitted sworn affidavits to the court, and subsequently they testified on the road. Why don't you contact them? Do you think she contacted one of the witnesses that said that the GAL falsified their statements? Of course not. But then she wrote his blatant lies about what his recommendations are. She didn't even bother reading the GAL report to see that it's not true. Whether one agrees with the GAL or not aside, he tells her that he recommended, and then you read his report, he didn't recommend that at all. He recommended primary custody to stay with Heather and some restrictions on video calls and what have you. And then he made some cosmetic changes to, like, the exchange, to give some appearance of impartiality on some logistic matters, while basically saying that the abuser should have the primary custody. This so-called investigator didn't even bother reading the GAL report, didn't bother contacting any witnesses, but she contacted her friend at the SHS. This is the other organization that refused to investigate. And I'll mention her name. She's going to be named in the lawsuit too. Amy Roberts. Amy Roberts is a par excellence enabler, apologist for female against male violence. This is not to diminish violence going the opposite direction, but I'm talking about corrupt state actors such as Lisa Noonan and Amy Roberts, literally. And so Amy Roberts told Lisa Noonan how I'm dangerous because I asked her and her agency to do their job. No phone calls, all communication via email, all emails saved, never threatened anybody, because Linda Irish said that I threatened her. And then William Singer, whom I did call a crook once I read his report and spoke to my witnesses. Oh, Mr. Tosic disclosed the GAL report to his friends, and GAL report is supposed to be confidential. Like, exactly. I know that my friends wouldn't say these things about me, so I asked them, and they said on the road that you son of a bitch lied and distorted and made up that I was forceful with my ex-wife, whereas they testified that they witnessed her abusing me during the Skype calls. How am I going to establish this unless I share with them what you, lying crook, court-appointed GAL, William Singer, wrote in your report? All of this was presented to the trial court. All of this was presented to the Court of Appeals Division 1 of the state of Washington, which, as you correctly observed from your Pennsylvania or other experience, they don't even read or review the evidence. And some of it was submitted to the state Supreme Court. And the only thing the state Supreme Court did was to make sure that I cannot submit more than they feel like reading, not that they read anything of what I originally submitted. That's the judiciary in the woke Soviet Republic of Washington. So if somebody feels offended with what I call this state, what am I supposed to think and feel about this state? I regret the day I set my foot in it. I didn't get out of one communist shithole in order for my daughter to be raised in another. And this state is a excuse my language, it is corrupt as hell shithole. And until things are moved by myself, Tony Card, and other parents who have had it, of all these years and decades of abuse by these kangaroo courts, until these things are moved through massive, massive tort and civil rights lawsuits in the federal court, nothing is going to change. Lives are going to continue getting destroyed on a whim by these sociopath tyrants wearing black with zero accountability. I'm not saying all judges are like this. I'm saying many are. Not just one or two family court judges.
Yeah.
Because again, what I'm summarizing today is my experience with primarily Court of Appeals Division 1 in the state of Washington, and limited but still negative experience with the state Supreme Court. On some of the matters that I elevated from Division 1 to the state Supreme Court as the highest state avenue, I'm not going to see any justice. And it doesn't matter how much things are documented. It doesn't matter that I have undisputed evidence, undisputed sworn statements, not challenged by the opposing counsel at all. They just, including appellate court, they just look the other way.
Yeah, because everybody knows everybody.
That's a big part of the problem. So let me give you an example. The commissioner at the state Supreme Court, who repeatedly stated, of course, he denied everything I filed back in around December, January. And then he repeatedly stated, why is Mr. Tosic complaining in the new parenting plan he's given more residential time with his daughter than the prior parenting plan? Marianne, do I need to tell you this is a blatant lie? Moreover, horrible and abusive as Dishonorable Sean O'Donnell is, in his rulings from November 2021, he clearly states that he's reducing my residential time. It's not my opinion. It's what's in the ruling, while using the Washington, revised Code of Washington, whatever it is, 26.something.191, these notorious 191 restrictions. He also takes away my decision-making about my own daughter as a fit and loving parent who was never found unfit, neglectful, or anything. Multiple people testifying that I'm an excellent father. He probably said that I was a better father than I would say of myself. None of that was disputed. Multiple, from Pullman, from Spokane, different church communities I've been involved in over the past. All of that is ignored. My decision-making taken away, my residential time reduced. In two places in his ruling, this clown, that is the commissioner of the state Supreme Court, says that my time was increased, so why am I complaining? Then he engages in the First Amendment retaliation, basically for me daring to call crooks without reviewing any of the evidence. Why am I calling these people crooks? Do I just go on the street and call people names because I'm some kind of senseless person? No, all of this is documented, but it doesn't matter when the state Supreme Court refuses to review evidence properly before them. And then what turns out, I'm here in Spokane, and I have my own affiliation with Gonzaga University, which is one of the main universities in Eastern Washington. The commissioner at the state Supreme Court and the aforementioned commissioner at the King County Superior Court, Mr. Eagle, who was representing ex-wife while it was known he was to become a commissioner, were at Gonzaga Law School at the same time. Whether they have other affiliations, I don't know. But I said, look, this already gives, and again, citing federal case law, something that Matthew Phillips helped me with, constitutionally intolerable risk of bias. May the Supreme Court commissioner be removed because, he's engaging in a First Amendment retaliation against me. He is refusing to review evidence. He claims to review evidence, and then he writes nonsense, like prima facie nonsense, that my residential time has been increased, whereas the court order says that it's been decreased.
Yeah.
And he went to law school with this other guy that I'm explicitly naming as one of the crooks who should be disbarred. Instead, that jackass is now a commissioner in the so-called family court so that he can destroy more lives. Somebody who, by the way, Mr. Eagle advertised on his, I don't know if it's still up or not, but while he had his legal practice, on his website how he was raised without a father, and so now he's trying to make other children in the state of Washington fatherless as a part of ideology and for profits. So I brought up this conflict of interest between the attorney / commissioner at the trial court and the commissioner who reviewed my case at the state Supreme Court. That was ignored and subsequently denied by what they call department, which is the Supreme Court judge, Mr. Gonzalez, and some 4 judges out of 9. All of that was denied. I also issued a request to take judicial notice on indisputable facts, such as there is no time travel of people. Because again, I talked about it last time, there were these blatant lies by William Singer and Linda Irish in their respective reports, including their statements under oath at the trial. And of course, my request to take judicial notice was denied, no justification. Also, I listed violations of the due process of the rules, state and federal rules of evidence and so forth. That was denied, no justification, just denied. The only thing that the state Supreme Court to date put any time and effort into was how to restrict what I can submit in the future, because why should I bother them with hundreds of pages? And again, I did submit several hundreds of pages because previously, hey, it's conclusory, it's all your opinion. No, it's not my opinion, here's the record. I mean, the corruption is awful and it goes all the way up to the state Supreme Court. But going back to what you just said, Marianne, so I found a link between the state Supreme Court commissioner and a normal person would say, look, I'm just going to recuse myself. But I'm not dealing with normal people or people who have any interest in justice. They're drunk with power. They know that they're not accountable to anybody, and they're doing whatever their whims are.
Yeah, it's not getting better anywhere. If it's your state, any state, it's just bad everywhere.
But Washington is one of the worst. And I do want to say one more comment. And, your fellow investigative journalist, Michael Wolpe, commented on this, and I agree, but respectfully disagree with him. The tragic incident in Maryland, and I haven't been on your side of the country, but I think I shared with you, I'm a University of Maryland undergraduate, graduate. So I have some ties, even though it's been many years. I'm a UMBC alum. The judge killed in Maryland. And a year ago or so, a year and a half ago, a guardian ad litem killed in El Paso, Texas. I do not excuse or justify. These are tragic incidents. Lives have been lost. Families have lost fathers or other family members. But let's not pretend for 1 second that what happened in Maryland or what happened in El Paso, Texas, is surprising. The guy who killed the judge in Maryland, a father of 4 children, never had a prior criminal record or a history of mental health disease. These tyrants in black robes, I do not know enough about that judge. I'm making a general statement here. Tyrants in black robes at the so-called family courts, literally on a whim and for profits, destroy people's lives.
Oh, exactly.
I am claiming that it's fathers disproportionately, but of course it's mothers. I'm friends with some of the mothers, such as Monica Chavez, that I believe you know, down in
Oh,
Albuquerque,
yeah.
New Mexico.
Yeah.
And she had her daughters with her a few months ago when we spoke, and then more recently she doesn't.
Mhm.
Like me, perhaps even more so than me, she has limited financial means, and she's getting abused by the system as well.
Oh,
So don't
yes.
get me wrong, it does happen to mothers too. It does happen to fathers disproportionately, especially in uber woke states such as Washington. But
Well,
back to this thing, people don't know what to do. Because
right.
then, well, you present evidence and you go to the Court of Appeals and you make sure that you follow the rules of the appellate procedure. And then they're going to review the evidence.
Mhm.
And, they're going to review whether the judge followed you do all of that. And they laugh into your face.
Oh, they do.
Not justify or excuse what happened in Maryland, but it's not surprising
Mhm.
because people's lives get destroyed on whim of these tyrants. And they are tyrants, accountable to nobody. And then some people just lose it and take matters into their own hands. I do not justify or excuse any of that, but it doesn't surprise me that, if anything, it surprises me that it doesn't happen more often.
Oh,
Something needs to be done because this is tyranny by the most corrupt and least accountable branch of state governments, the judiciary. Of course, they're embedded with the executive branch through, for example, the Title 4D program. Let me just give you one more example, insofar as investigating and then presenting evidence to the appellate courts and then being ignored. Uh, the commissioner who first ruled on the adequate cause back in 2019, but who wouldn't change temporary custody in spite of prima facie evidence and arrest of a female abuser,
mhm.
and who, moreover, wouldn't even reduce or change or modify anything with regards to the so-called child support, this racket masquerading for child support. The
Mhm.
King County's clerk's office confirmed, his name is Jonathan Lack, and Tony Card is naming him in his lawsuit, and rightly so. Mr. Lack is directly paid out of the Title 4D program. So these people have direct, what they call pecuniary, financial conflict of interest.
Mhm.
Everybody reasonably informed about how Title 40 operates knows it. And even when you raise it like I have been, I wasn't raising it in 2018, 2019. I had a lawyer then. I was represented or misrepresented, as it were, and I didn't know much about Title 4D. I do now, and for the past 2 years. I've been raising this repeatedly with specifically Court of Appeals Division 1, and where applicable with the state Supreme Court. It's all ignored. All these
Oh,
financial conflicts of personal and professional ties. I've been asking a Division 1, the told judge's ex-wife, who has a very wealthy family, is represented by a ruthless but very expensive law firm in Seattle, appellate law firm, Goodfriend Smith. So I asked that all judges at Court of Appeals Division 1, to whom partners at Goodfriend Smith committed to their campaigns, recuse themselves.
mhm.
Where do you think that went?
Nowhere.
Ignored.
No.
Nowhere. And I guarantee you, Goodfriend Smith they're not very ethical lawyers, but they're very expensive lawyers and they're extremely well-connected lawyers. Just like Mr. Eagle, who is now a commissioner, while he was an attorney, was very well connected to these judges in King County. And I raised that and nothing. If you don't have the Johnny Depp money,
Mhm.
or better, there is nothing you can do.
Well,
Until, go ahead.
or if it's so colluded, like, well, say anybody's case, even my case, if the opposing attorney and the judge are BFFs, you're going to lose anyway. You could walk in there with a Hollywood team of attorneys and you're still going to lose.
No, I agree. But then how in the world, especially if you timely raise, how in the world these people don't recuse themselves?
Because they know they want to make this money, this Title 40 money, because the Title 40 money
They're
also
invulnerable.
goes it also goes into their judicial retirement monies.
Oh, that too, absolutely.
So yeah.
So the whole system is incentivized the wrong way. And I agree with what you just said. And again, Johnny Depp not only had the money for lawyers, but it got the publicity and all that. And
Yeah.
so that's why they couldn't so easily do the hush hush or have people with blatant conflict of interest, such as in my case. And so, I don't know. I'm not sure that the federal lawsuit is going to work, but what I do know, and what I suspected a year ago when I was on your show for the first time, what I know for a fact now, is that going through the standard appellate procedure through the state courts up to the state Supreme Court, it's not going to get me anywhere. The
Oh,
corruption and these old boys and girls club, and
yeah.
people who are intertwined professionally and otherwise, who are protecting for each other. Because, if I won on any one of these appeals, the whole tower of cards, of the dominoes would start, falling down, going all the way to the fraud that the judge and the commissioners at the lowest court were involved in, and the cover-up and violations of the due process and the Court of Appeals is the next level. All the dominoes would start falling. And so it doesn't matter what evidence I present and what particular specific sub case, if you will, whether it's removing a commissioner from the Supreme Court, asking for these judges to step down. I've been still seeking and got denied recently that the trial judge be removed with all these additional volumes of evidence of his abuses. None of it matters.
It's so
And,
sad.
we are out of time, but I was tempted to read some of these rulings because again, the judges in Washington at the appellate court and then the Supreme Court don't give any justifications. Commissioners sometimes do. And these justifications, these factual and legal, summary of facts, they get basic facts wrong. You bring it up, you get ignored. And they write complete nonsense that is an insult to anybody's intelligence. This clown in the Supreme Court wrote at 2 places that I'm given more residential time. He didn't even read the order. It's a complete joke. This other commissioner at Court of Appeals Division 1, she literally said, well, Mr. Tosic is seeking, disqualification of the judge because, and she did list relatively correctly what I alleged against the judge, and that's a long list of violations of the Code of Judicial Conduct, oath to office, federal law, the Constitution, you name it. And then she basically says, well, Judge O'Donnell has allowed for oral hearings. He has admitted some written documents, and then he has cited in his ruling some of his, and of course he miscited me. And the Court of Appeals doesn't care. The Court of Appeals doesn't cite my argument against the judge. They cite judges' interpretation of my argument. It's ridiculous.
Right.
And so therefore, since the judge allowed for this, basically, Mr. Tosic hasn't presented sufficient evidence of judges. So I'm with all due respect, this argument is complete nonsense. Joseph Stalin's courts and Nazi Germany's courts and Comrade Mao's courts allowed people to show in court and to submit some documents, and they cited. This is just superficial. I cited violations of the rule of evidence. I cited undisputed sworn testimonies and affidavits and evidence being ignored. All of this is procedurally against the law.
Oh, yeah.
None of that is mentioned. Rather, the commissioner writes, first off, she gets all the facts wrong, including the timeline of events and all that. She calls it, interlocutory rulings are disfavored. This is not even an interlocutory appeals, rather. This wasn't even an interlocutory appeal. But that aside, she gets the factual, the timeline, the causality of events all wrong. And then her legal analysis boils down, well, the judge allowed Mr. Tosic to be heard, to submit some documents, and then the judge, cited some of those documents, and then the judge decided as he decided. And you can't just go seek judge's disqualification just based on his decisions. And by the way, I cited that I was literally denied to use the restroom during the trial.
Typical.
Just a form of intimidation and all that. I was repeatedly silenced. I was prevented to cross-examine the guardian ad litem. So even if you say, well, you can't disqualify judge on his rulings, regardless of how senseless they are, here all these abuses, procedural violations, violations of the due process. I wasn't allowed to subpoena key witnesses, such as ex-wife's mother, who witnessed multiple instances of her abuse against me. Of course, she would lie on her daughter's behalf. She already did. But guess what? I'd get to cross-examine her. And because Mr. Eagle and Mr. O'Donnell both feared that, they shortened my cross-examination of ex-wife. They had to put her on the stand to give some appearance of, But then I couldn't subpoena ex-wife. My cross-examination of the key witness, William Singer, one of the key witnesses, the crooked GAL, was arbitrarily interrupted and ended as I started exposing his lies. Sworn testimonies by my witnesses, the GAL literally falsified, materially distorted and falsified their statements, was completely ignored, even though it was not disputed. This is not just abuse of discretion. This is abuse of the basic due process. Exactly. And then during the 6-day trial, I, who do have certain health, I'm not, anything, but insofar as physical health. But there was one time I used the restroom while the other attorney was getting their witness ready. And then the second time, Your Honor, and it was a Zoom trial, by the way, it's going to take 2 minutes. I apologize. I need to use the restroom. And I had that in the transcript. I thought they would edit the transcript. They didn't. So I submitted that piece of the transcript to the Court of Appeals. Look, this is how I was treated by this judge. It's not just his decisions, senseless and ridiculous and not based on any evidence or logic or facts or law. as they are, it's also his behavior, his denial of the due process, interrupting and disallowing cross-examination of key witnesses, my cross-examination, and not even letting me use the restroom. What more evidence do you need that this judge was biased against me? No. According to this Kangaroo Court of Appeals Division 1 in the woke Republic of Washington, nothing apparently is enough to remove a judge.
There's just never enough corruption, but I'd like to have you come back on with some more updates.
Well, the main thing that I was telling you last year, this time it does need to happen, and soon, is a federal lawsuit. Not because I enjoy going back to any court, but because there is no other way. Because the state of Washington is so corrupt, and I agree with you, it's not the only, but it's a prime time example of the family court corruption, but not just family courts. It literally goes through the appellate courts all the way up to the Supreme Court. And it's sad. It's outrageous.
It is.
And my daughter, who is a wonderful kid, who I love dearly, she's the only child I have. She's, getting better at math and writing. She's still biting, a habit she learned from her mother. Her mother was never evaluated for mental health, which any society and any legal system that remotely gave a hoot about children's well-being should have done 4 or 5 years ago. Because there's no money to be made off of that.
Exactly.
The money is to be made over ordering child support onto me, whether I can afford it or not. In 2018, I had a full-time job. I could. The last 2 years, I could not. They know it. And the state is still going after me. The same Spokane County, this is going to be the last thing I'm going to say, the same Spokane County prosecutor, when I filed crime reports for felony grade fraud on the court, including in Spokane County, by Mr. Eagle, ex-wife, and some other attorneys working on ex-wife's behalf, knowingly submitting fraudulent reports to the court, the response was that the county prosecutor's office, who, by the way, is nominal Republican, for what it's worth in the state, that is, for all intents and purposes, very, one party. But, in the Eastern Washington, Republicans have some representation. Anyway, the response was, and it's a joke, I mean, that whole thing, the response was they don't have resources. So I'm like, this is felony grade crime. And it's not a victimless crime because I'm the victim, and indirectly so is my daughter. No resources for that. The state and the county prosecutor's office would spare no resources going after me for the so-called child support, knowing, even if they didn't know at the beginning, they know by now, that I was involuntarily unemployed, that I'm disabled, and that I've been found indigent by multiple courts. They don't care. The purpose is to silence me, to destroy me. They want to destroy my daughter's father because I've been talking about corruption. And I'll keep talking on your show and everywhere else till my last breath. These people are criminals.
Okay.
These people are morally depraved criminals, and this needs to be said. Because this is not ignorance. This is not, we're just trying to enforce this. This is done maliciously, knowingly, intentionally. And it's an outrage. And the broader public needs to know about this.
Well, I'm glad you came on, but don't jump off. How can people reach you if they have any questions?
My email, predrag.tosic@ieee.org. That's the easiest one.
Okay, gotcha.
So first name, daughter, period, last name at IEEE, 3 E's.org.
Yep.
And they can also use predrag.tosic 7 at yahoo.com.
Gotcha.
First name, dot, last name, 7 digit at Yahoo.
Okay,
and I use this because I'm approaching the storage limits with some of my emails, and sometimes things get bounced off and so forth. So
that's okay.
And again, the very last thing, again, any attorneys who practice in Washington and who are willing to take onto the system, calling on in tort and civil rights lawsuit, which should be a multi-million-dollar lawsuit, to represent me, but also to represent other parents. In Washington, it's almost exclusively fathers, such as Tony Card, Stephen Hicks, and others, because we're also planning a class action, something similar to Matthew Phillips. God bless him, and down in San Diego for doing what they're doing. That's long overdue here in Washington State.
Definitely. Okay, don't jump off. Slam the Gavel is a podcast to help the public understand what really goes on in these family courtrooms. I am your host, Marianne Petrie, author of Dismantling Family Court Corruption, Why Taking the Kids Was Not Enough, and Cry Out for Justice, Poems of Truth, and recently released Raised by These Wolves, How Family and Federal Courts Are Destroying Our Children. You can find me on Spotify, YouTube, Apple iTunes, Anchor FM, iHeartRadio. Feel free to donate to buy me a coffee to help keep the podcast going. Thank you so much, Predrag.
Thank you, Marianne. I appreciate everything that you're doing with your other guests and so forth. The general public, most people in this country, most people anywhere are decent people, but most people are ignorant in
Oh, yes,
how,
definitely.
again, this most
Thank
corrupt
you.
branch of the government
Mhm.
abuses people and destroys children. So thank you for everything you've been doing to expose that.
Thank you so much.